So I remember something and I thought it wise to share. So sometime in court, the court was reluctant to declare that the tenant's relationship between a landlord and tenant was for a fixed term certain. Do you know why? You know why? Because the tenant did not sign that agreement. And when an agreement is not signed, the absence of that signature renders it not binding on that party. And you know, when it's a fixed term certain, the tenant is only entitled to the 7 days owner's intention to recover possession. And that is what the landlord said. And since the court is reluctant to found it to be a tenancy for a fixed term certain, the obvious happened. And the law is clear that where there is no tenancy agreement between the landlord and the tenant, the operation of the law comes into play. The provisions of the law shall apply, which is 6 months notice for a yearly tenant. So it reverts back to what the law provides. So that particular incident, the lesson is straightforward. Always make sure that those tenants, they review and sign the tenancy agreement before you hand over possession. Before you give them the keys to the apartment, let them sign. Let them sign. Because in the absence of a signature, it can be binding on them. Just like in this case. But be safe, let them review and then append signature before you hand over keys to them. Else, is a periodic tenancy. So you have to serve the 6 months notice to quit. And you cannot even rely on pillar's case, because pillar is if the notice is defective, not when you did not serve at all.